All right, this is case number 22-184-955. This is credit acceptance versus Adafa Miller. The matter is before the court. Looks like for a first hearing, I do see where an answer has been filed to the complaint in this matter. Your appearance for credit acceptance, please.
Judge, may I please the court? My name is Attorney Richard Rusin. My bar number is 35222. I am the attorney of record for the Credit Acceptance Company.
All right, thank you, counsel, and good morning to you, sir.
Hi.
I'm looking now for Adafa or Pamela Miller. If you on the Zoom or you're represented by counsel, someone please say something at this time.
I'm Pamela Miller.
All right, thank you, Ms. Miller, and good morning to you, ma'am. I see that you did file an answer to the complaint, and in filing your answer, it looks like you agreed with practically everything you said. You spoke, and you'd like to make payment arrangements. Is that correct, ma'am?
Yes.
Well, you said you'd like to pay $744. You know that this is a claim that alleges $3,700. You understand that?
Yes.
So are you saying to me that that you believe that you owe this money?
Yes, Your Honor. I have paid $200 of that amount, and I agreed that I owed the rest, or my son supposed to have paid it by August. The remaining balance, credit acceptance, or the representatives who are for credit acceptance agreed to give a final decision payment of $700.
Let me talk to Mr. Wilson. What's going on here, sir?
Yes, I think that's true, Judge. I'm looking at my notes. So I think that it would probably be best to just have this case continued for a final pretrial settlement. I am optimistic that based on the way that this case is proceeding, that I'm in my heart of hearts sure that Ms. Miller will pay the entire settlement, so I can just perhaps at the next final pretrial conference issue a court before then file a dismissal.
All right, that makes sense to you as well, ma'am?
What final settlement?
No final pretrial conference.
I'm sorry, I
Yeah.
can't hear you.
The apparently you reached a final settlement, but it hasn't all been paid off. And Mr. Wilson is asking that I set another court date, and in between now and that time, this the final payment should be made, and then he would offer a petition to dismiss the case. That makes sense to you?
Yes, but I still don't understand what the final settlement amount was. It 700 or 30,000?
No, it's whatever she agreed with my office, but she's got to pay the whole thing so I can dismiss the case.
Right. So you have a balance based upon the amount that you agreed on. Whatever you agreed to, that is the agreement that you have. I don't know all the details of it, but there's nothing's going to change about that as long as you go ahead and pay that off. So whatever number you agreed to, that is the number that you have to finish paying off. You understand?
Yes.
All right. So there's no new settlement or anything. You've already reached the settlement. You've just got some payment that's still got to be paid off. And so the request is that I adjourn the hearing so that you can finish making the payment, and then the case would be dismissed. That makes sense to you?
Yes, it does. Thank you, Your Honor.
All right. Mr. Rosen, how much time are we here?
Well, Judge, I would gently suggest maybe 60 days from now that will place us towards the end of September.
All right, so I'll go ahead and open the window that wide, if you will, and send it over for the latter part of September. That date's going to be
September 26th.
9/26/22. And I'm setting this on from 9:30 a.m. Obviously, if the final payment is made and all of this is taken care of, then what will happen is I'll get an order dismissing the case. But I am setting that control date just in case something goes wrong. Right. I wish you well. You'll get a notice in the mail, ma'am, and thank you, counsel.
Thank you, Judge.
Thank you. Do I stay on Zoom?
No, you're all set, ma'am.
Okay,
Good day to you.
you too.
All right, the court calls case number 21-169-886. This is Dynamic Medical Supply LLC versus City of Detroit. The matter is before the court settling for a pretrial conference date. All right, your appearance for Dynamic Medical, please.
Good morning, Your Honor. Michael Fergustrom, bar number 48864 for the plaintiff Dynamic.
Thank you, Mr. Ferguson, and good morning to you. For the City of Detroit, if you will, your appearance.
Mr. Patterson says he had to go to another courtroom to deal with that. He has 2 cases.
All right. I've been notified that Mr. Patterson was here and says he has to go to another courtroom. Did the two of you talk at all, Mr. Ferguson?
We have not, at least not this morning, Your Honor.
All right. So just stand by. I'll get right back to you, sir. Let's see if we get Mr. Patterson back in. I'll get right back to you. So just
Certainly.
stand down.
Thank you, Your Honor.
The court now calls case number 21-171-326. This is Z-Ride Home LLC versus City of Detroit. The matter is before the court set on for a pretrial conference date. Your appearance for Z-Ride Home at this time, please.
Morning, Your Honor. John Betts for plaintiff. This case is in the same status as the one you previously called. Mr. Patterson will be rejoining us shortly, and I ask you pass this momentarily till we get Mr. Patterson back online.
All right. Thank you, Counsel. Thank you for your indulgence. I will pass the matter and I'll come back to yours as well. This is case number 22-182-312. This is ZMC Pharmacy LLC versus Smart. The matter is before the court. Looks like it's set on for a pretrial, strike that for a general hearing. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Casey Pullman for Plaintiff ZMC Pharmacy.
And your P number, if you will, Ms. Pullman.
85497.
Thank you, Counsel. Good morning to you. I'm looking for Counsel for Smart at this time, please.
Good morning, Your Honor. Deborah Brycely on behalf of Smart P45123.
Thank you, Ms. Brycely, and good morning to you as well, ma'am. All right, I see that there is the filing of an answer, but it looks like all of this happened in May. But I take it that it looks like it's maybe the first time up in front of me. Somebody update me on the status of things at this time.
You're correct about that, Your Honor. We do need a scheduling order still, and it has ended with the answer from defendant.
All right, thank you. Ms. Brycely, anything you wanted to say, ma'am?
No, that's correct, Your Honor. It's our first appearance, and I believe this is a matter that we'll be able to work on and expeditiously take care of.
All right, very well. So my inclination is a 60-day open discovery order. It might even give you a few days beyond the 60 days, but I'll have you come back in late September. I'm going to give you a specific date in a moment. Discovery would remain open through the next action date, which would be a pretrial date. You would also have the opportunity to file motions during that period of time, notwithstanding the court rules typically provided in such cases under the court's order. You'd be able to file a motion dispositive or otherwise and have it heard on that same date so long as you provide the opposing party at least 10 days opportunity to respond prior to the hearing. So if something comes up along the way where you file some motion that might dispose of the case or some other issue that you wish to bring before the court, you will have a motion filing date. That is the same date of the pretrial. Just make sure the other side gets at least 10 days. That will be in the court's scheduling order. It will be under paragraph number 6, and you'll get a copy of the scheduling order in the mail. Other issues of schedule will be addressed at the subsequent pretrial date, which I'm going to give to you now. To get it resolved, the court will review where we are when you come back in September. That date's going to be
September 28th.
9/28, 22, and the return time is going to be 9:30 a.m. on that date. You'll get a scheduling order from me in the mail in the next couple of days. It'll have that return date. It will also have the discovery order, and it will have the right to file motions contained in that document. And again, you'll get a copy of the mail shortly. All right. I wish the two of you well. Good day to you.
Thank you.
Thank you, Your Honor. Is there any discovery allowed as far as interrogatories or deposition? Should we decide that those are necessary?
Yes, I'm allowing for open discovery during that period of time. So, you know, you can do the things that you like to do. Just make sure that it's reasonable under all of the circumstances. And a lot of times calling up and saying, well, I want to do this, especially with depositions, the parties can kind of come together and figure out how to go forward with that. But I suppose you know how to kind of get at it. I just don't want people falling out and wasting time about nothing. But otherwise, go and do what you have to do, and I'll see you on the 28th of September.
Thank you, Your Honor.
Thank you.
And I do see that Mr. Patterson is back. I'm coming to you in just a moment, sir. Let me address 20-164-776. That's Ford Transportation Incorporated versus Michigan Auto Insurance Placement Facility. I am revisiting this matter as an adjourned pretrial in this matter. Your appearance regarding Ford Transport.
Eric Stone, appearing on behalf of the plaintiff, P55304.
Thank you, Mr. Stone. And
You're welcome.
And for the defendant in this matter, you made at this time.
I believe Miss Mahone.
Yeah.
Lisa?
Ms. Mahone, are you available, ma'am? Your appearance, please.
There she is.
I apologize. Talitha Mahone on behalf of the MAIPF, P number 79890.
All right, thank you, Ms. Mahone. Somebody update me. I know I signed some orders allowing for a deposition and a follow-up. I know that there's been a bench warrant issued at some point in this matter. Somebody update me on where things are.
You're right on, Your Honor. There was a bench warrant issued. She never responded. Defense filed a summary disposition, but I'd just like to point out that MAIPF is not the proper defendant in this case. They have to turn it over to a carrier, and they've never turned it over to a carrier yet.
Well, that's the basis of our MSD, Your Honor. We filed an MSD based on the non-cooperation of the underlying claimant and not having a reasonable proof of loss ever provided to us in this matter. So that's the basis of the MSD that was filed.
So your argument is that the predicate to turning it over to a particular in some particular way is based upon whether or not there is a sufficient proof of loss or the underlying predicate of the case is established before your office would then direct that someplace else. Is that correct?
Yes, that's correct, Your Honor. We don't have the sufficient proof of loss to even know if she was involved in an accident or injured. And we never had her deposition completed to be able to obtain the information needed to determine eligibility for assignment. So this case wouldn't be assigned until we have that information, and we don't have that here.
Your Honor, I'd like to point out that
you're not just a clog in the system. You're arguing that that as it comes to your office has to exercise a certain amount of due diligence to see whether or not the predicate for the claim is satisfied, at least facially. That's what you're arguing, Madam Counsel.
Yes, Your Honor.
All right, and I'm back to you, Mr. Stone. Sorry, sir.
Yeah, I'd just like to point out, this is a non-party to this action. So to dismiss a case on it, we can argue the motion, but I just want to let you know, this is a non-party to the action. She is not a party to the action. So the court, our legislature, we can argue the motion under 500.3112 allows direct causes of action for an injured person. It doesn't say anything about first qualifying the person or anything like that. I'm reading the statute verbatim. A healthcare provider listed in section 3157 may make a claim and assert a direct cause of action against an insurer or under the assigned claims plan under sections 3171 to 3175 to recover overdue benefits payable for charges or for products, services, accommodations provided to an injured person. Okay, and it says period. So
Right. I think that your reading of the statute is absolutely 100% on point and sits on all fours. The challenge becomes the reality that the independent claim that can be brought by providers is not divorced from the statutory requirement that there be a proof of loss. And I think that what counsel is arguing is that the predicate here, notwithstanding the fact that this case is not controlled by the fact that the plaintiff is not the underlying claimant, if you will, but it's controlled by the statute that says that notwithstanding who the claimant is, that there has to be the required proof of loss. I think that's what's being argued here. Go ahead, counsel.
yeah, but that's not what the statute says, Your Honor.
All right, thank you, counsel. Just one moment. Let me hear you, Ms. Mahone.
Your Honor, I think you're directly on point. That's what the statute says as it relates to claims to the Michigan Assigns Claim Plan. Under 500.3173A, it says that a person submitting a claim under the Michigan Assigns Claim Plan must cooperate with the eligibility for assignment, determination of eligibility for assignment. One of the things required is reasonable proof of loss under section 3172. And the person must cooperate with appearing for an examination under oath. We don't have plaintiff's cooperation with producing reasonable proof of loss. That might have been able to be refuted by having the person's deposition, the underlying claimant's deposition, but we don't have that either. We don't have the prerequisite requirements that are needed in order to even determine on its face that this case would be eligible for assignment.
Section 3172 is for, well, okay. It's not what the statute says if you read in its entirety. The legislature made a loophole and allowed providers to bring a cause of action for an injured person. Okay, it didn't say it had to prove a right, didn't say anything. The problem is it's a very badly, poorly written statute. And now people such as the providers have no direction. As pointed out in our case, you have not cited any case law and there's been no case on this post-accident. So this is a case of first impression and it hasn't been decided yet. And to throw our case out because there's no cases citing it on a non-party's cause of action, that's not correct. There is not one case cited.
Yeah, I guess without there being a case cited, that's certainly a significant consideration. I guess a part of the concern is that it's very clear how the statute works as it relates to providing the necessary predicate for the claim. There has to be a reasonable proof of the claim presented, whether it is the provider or whether it is the underlying claimant. That all of this is secondary to the no fault statute and its various revisions, which one of the most accurate things that Mr. Stone says is that certain aspects of it leaves a whole lot to be desired for sure. But I think one of the things that is not left where there's not any room really left, is that there has to be a reasonable offer of proof relative to the claim and a proper notification of the same. And oftentimes, notwithstanding the fact that a provider has an independent claim, if you will, under the statute, there is oftentimes a necessity to back up into the claimant to get information that becomes a predicate for making the claim. Go ahead, Mr. Stone.
Yeah, Your Honor, it's kind of funny you bring that up, and thank you for doing that. The next point I would like to put, when you fill out your application, you don't need a police report, Your Honor. What if the person is dead and there's no witnesses? You still get benefits, all right? What you need is people get in car accidents, they go to their doctors and make a record of it. In fact, in the Michigan Assigned Claims Plan, it says police report and or medical documentation. People go to doctors, they tell them they were involved in the car accident, the doctor's related to the car accident. You don't need a police report, you don't need a witness. This is under the MAIPF's own rules.
Right, so what?
Hold on, excuse me. Someone can go to the ER, make a claim, and if this was Beaumont Hospital would not lose. It's the same thing with medical providers and hospitals, okay? They have independent causes of actions. The medical records are sufficient under the Michigan Assigned Claims Plan. It does not have to be a police report. It doesn't have to be witness statements. Medical records to prove your case are admissible, and they're asked for by the Assigned Claims Plan to prove eligibility. So there are records. This person got in an accident. It doesn't say you have to go to the ER right after. It says medical records. This person chose to wait some time, then went to the doctor and said they were in a car accident. That is what the MAIPF plan says. So medical records are used to prove that there was an accident, and it is not necessary or required to prove eligibility. A police report is not, or witnesses.
I totally agree with you that the medical workup can ultimately be used to prove that there is that there were expenses incurred and so on and so forth. I think we're talking about something different here. You argue, you bunched it together and said that eligibility is established by the fact that there is a field. Counsel.
Yes, because under the no fault statute, it says to prove eligibility, you can put in your medical records. It doesn't have to have a proof. What if it was a hit and run, Your Honor? There's no proof wherever. There's no police report. It's only someone's name. It was a hit and run. And they go to the medical records, and in that hit and run, the person disappears. This isn't a claim. The state of Michigan set this up poorly, where they now have to subrogate against the claimant, which she's already trying to do by subpoenaing her and throwing her in jail. They need to pay the claim and subrogate against. That is what this is all about. We've provided proof. We've provided medical records that show she was in an accident. There's nothing more we have to do. It's a question of fact for the jury whether or not that's enough evidence to get an award. This case should not be thrown out.
Thank you, counsel. Ms. Mahone, why, under circumstances where the plaintiff is able to present proof of treatment, proof that the person being treated alleges injury resulting from an automobile accident, why should the claim not survive under those circumstances?
Thank you, Your Honor. I think Mr. Stone is mistaken in what the requirements for MAIPF under the assigned claim plan is requiring. The statute MCL 500.3172 parentheses 3 says that a claimant shall file a completed application on a claim form provided by the Michigan Automobile Insurance Placement Facility and provide reasonable proof of loss to the MAIPF. The MAIPF or the insurer assigned to administer the claim shall specify in writing the materials that constitute a reasonable proof of loss within 60 days after receipt of the MAIPF application that complies with this section. So the statute doesn't specifically say any medical records that may come in satisfy reasonable proof of loss. The statute leaves that up to MAIPF to define that. And what MAIPF has consistently done and consistently sends out letters, and I'm trying to look for the letter in this particular one, but what they do is that they say that medical records can suffice for reasonable proof of loss if it's from the date of the accident, from the date of loss. If we have medical records that weeks, months later, we can't show that it's related to this particular accident. So anyone can walk into a medical provider and say, you know, I was in an accident 2 months ago, but we don't know that that's related to this particular accident. So we don't have a police report that would help satisfy. We don't have emergency room records or ER records or any other medical records to support that the person was in the accident on this particular date of loss. Urgent care records on the date of loss could be helpful. And on top of that, we don't have the underlying claimant's deposition to help establish that she was actually involved in an accident on that date of loss.
Your statute, your rules don't.
No, Mr. Stone, stop. Stop waving your hand, raising your hand, all of that. Stop. That's a distraction. Stop. All right, Ms. Mahone, you may continue, ma'am.
Yes, Your Honor. So in this case, we don't have a police report naming the injured party. We don't have emergency records or urgent care records from the date of loss. All we have are the provider's medical records that are saying that they treated this individual at some point in time, but we don't know what it's related to. So that's all we have in this matter. So that's why this case has not been assigned. And due to that, we believe that this case warrants dismissal, Your Honor.
Your Honor, one more thing.
Mr. Stone, let me ask you, the medical workup and treatment provided by your client, does those documents make reference to an automobile accident and the any issues regarding date of injury or anything?
I don't have them in front of me, but I would like to point out that Ms. Mahone was incorrect in saying that her own rules state it has to be from the date of the accident. It doesn't state that in her own rules. And if you can provide that, Ms. Mahone, I'm sorry, but I'm not mistaken. You misled the court in saying it had to be an ER record or an urgent care record. Your internal rules say police report and or medical records. It doesn't say ER records. That's the position MAIPF is taking, and that's why it's always litigated, because that's wrong, because it doesn't follow the statute. As far as the medical records state, Your Honor, the date of the accident was on January 16th. The medical
records.
The billings show that she did go to the doctor on January 16th, the date of the accident. There's a transportation bill to that effect. She started her physical therapy on the 28th. So she did go, if you want to buy her, that she did go to the doctor on the date of the accident.
I have the date of accident as January 14th, 2020.
Hold on 1 second, ma'am.
Okay.
Mr. Stone, go ahead, sir. Are you finished?
Oh yeah, so she went to, she began treatment 2 days after. The accident was on the 14th.
All right, thank you.
So,
Ms. Mahone, wait a minute, Mr. Stone, are you done?
Yeah, I would just like to, I'd like to get proof that Ms. Mahone has misled this court and that it has to be an ER record and an urgent care record.
Well, I can give you proof of that. There's been no misleading of the court. She's offered argument, you offered argument, and you differ on the various positions that you take. The notion of misleading the court, I guess if a lawyer says something that is in disagreement with the other lawyer on argument or point, and there's a whole lot of lawyers that are misleading the court. I don't think that's a reasonable argument under these circumstances. Your point is well taken. Otherwise, Ms. Mahone, you get the last word.
Yes, Your Honor, and I appreciate that. I'm not misleading the court. What I said was that the ER records are enough to satisfy proof of loss because it's typically from the date of the loss. I gave examples of things that would be from the date of the loss that would satisfy proof of loss, including emergency records, urgent care records, or treatment from the date of the loss. That's all I was indicating. Medical records are enough to satisfy reasonable proof of loss from the date of loss. And Your Honor, I'll end at that.
All right, I listened to the argument on the motion for summary disposition in this matter. And really, what the issue comes down to is that there is a genuine material issue of facts, genuine material issues of fact there in dispute. And that's really what's going on here. If presented to a jury, maybe the plaintiff would not be able to carry the burden here. But as it relates to whether or not the plaintiff is foreclosed legally on what may be a thin sheet of ice to skate on, well, the reality of it is that there is some proof. There's some proof of loss that is being shown, and obviously the defendant in this matter would like to see a greater quantum of proof of loss, but there is some here, and that amount, small though it may be, is sufficient for this case to survive the motion for summary disposition. And for that reason, I'll deny the motion for summary disposition, finding that there are genuine issues of material fact for a trier of fact related to this matter. The motion be denied accordingly. All right, so you thought about all right, so maybe I'll give you some time to think about whether or not you want to appeal me, or do you have some other direction that you like the court to assist the parties in as it relates to this matter?
No, Your Honor, I think a new settlement conference date and defendant and I can get together and hopefully resolve this.
All right.
Yes, Your Honor, that's fine if we get another settlement conference date.
All right. I will set the matter over for a settlement conference date, and let's see where things are at that time. If I have to begin to put it on a platform for some type of trial, then we'll get that done at that time. But let's see if we can move towards some meaningful resolution of this matter. So we're looking at September. A little
Earlier, September 21st.
9/21/22. And that's going to be at 9:30 a.m. 9/21/20. And in fact, let me put that at 10 o'clock. 9/21/22 at 10 o'clock a.m. You will get a notice in the mail in this regard. If you will, council, submit a motion, submit an order simply denying the motion for summary disposition. Well, no, that's okay. I'll get it done. I'll send something out to you in the next couple of days. All right.
Oh, the court's going to prepare the order?
Yeah, I'll take care of it.
Okay.
Thank you, Your Honor.
All right, thank you.
Okay. All right. All right. Welcome back, Mr. Patterson. I believe that Dynamics Medical was first. Let's see. Z-Ride was first. That's this case number 21-17-1326. This is Z-Ride Home LLC versus City of Detroit. Matters before the court, set on for a pretrial conference, and your appearance at this time, gentlemen.
John Betts, P24468 on behalf of the plaintiff.
Thank you, counsel, and Mr. Patterson, your appearance, sir.
Good morning, Your Honor. Ben Patterson, on behalf of defendant, City of Detroit, P number 85118.
All right, thank you, Mr. Patterson, and welcome back. Hope you got some things resolved.
Thank you, Your Honor. Yes, I had another hearing with Judge Robinson, so I appreciate you passing it and letting me come back. Thank you.
Your Honor, if I may interrupt, this is a transportation bill for Lady Navy.
It gets better. Can't do anything but get better. I'm kidding. Okay, go ahead, Mr. Betts.
This is a transportation bill for a lady named Shaniqua Hentz. Ms. Hentz has her own circuit court suit pending against the City of Detroit and against National General Insurance Company. Mr. Patterson has explained to me that the City of Detroit has filed a summary disposition motion seeking Judge Berry in the circuit court to make a determination that the city of Detroit is not highest in priority to provide no-fault benefits on behalf of Ms. Hens, but that National General would therefore be the highest in priority. That motion is scheduled for hearing, I think, August 11th, Mr. Patterson, or anyhow, sometime fairly soon. And that Judge Barry's ruling on that motion would go a long way toward resolving our current district court case. So I'm going to suggest that we adjourn our pretrial conference till after Judge Barry hears Mr. Patterson's motion, adjournment of about 30 days.
Yeah, that seems to make sense there. Yeah. Mr. Patterson.
That's correct, Your Honor. So our renewed motion is set for hearing on August 11th. The press fee was actually accepted today. So I believe it will go on August 11th. And I will also note that three of the providers, this is jumping ahead, but they have sought to intervene, including the Dynamic Medical Supply, I know is up next. But I'm fine with the 30-day adjournment pending the court dismissing the city. I believe National General has been added to this case, or I don't know if they've been served yet, but I know the court gave plaintiff leave to add them.
All right, very well. I will go ahead and adjourn the matter, and let's put it in early September. Early to middle. September 14, 2022. It's 9/14/2022, and we'll set that over for 9:45 a.m. And I can see where the determination in circuit court could have a significant impact on how this matter proceeds. So we'll take a look at everything on that date. So it's an adjourned pretrial date. Court finally calls for the same, September 14, 2022, 9:45 a.m.
Understood, Your Honor. Thank you.
Thank you, Your Honor.
And we're on the record regarding 21-169-888. This is Dynamic Medical Supply LLC versus City of Detroit. And your appearance once again, if you will, counsel.
Good morning again, Your Honor. Michael Fergustrom for the plaintiff, bar number 48864.
Thank you again, Mr. Ferguson. I actually think that you were supposed to go before the other one, but I kind of screwed it up a little bit. All right, thank you for your patience, sir. And Mr. Patterson, if you will, your formal appearance on this case, if you will.
Yes, Your Honor. Ben Patterson on behalf of defendant, City of Detroit, P number 85118.
All right, thank you, gentlemen. Enlighten me, if you will, regarding the status of things here.
Your Honor, this case is actually, in a sense, a companion case to the one you just heard. It also involves the same injured person, Ms. Hentz. And in this case, you've also granted leave for us to add national indemnity to the case. I think that we may pursue intervention in the circuit court case. But in any event, I would think that probably the same adjournment that you just granted in the previous case, perhaps even to the same date, would probably make sense.
Sounds that way to me, Mr. Patterson. What do you think, sir?
Yes, that's fine, Your Honor. I will note that I know a few different attorneys been handling it on plaintiff's side, but plaintiff Dynamic Medical Supply has filed its motion to intervene. All three providers represented by the Dollar Law Firm have filed a motion to intervene in the Third Circuit case. So I think that does make sense to adjourn to the same date, and most likely I would assume the court will.
Well, as always, the opposing counsel knows more about my case than I do. So thank you.
No problem.
You know, sometimes when you're defending, when you have one big client, you have the luxury of sorting out where everybody else is coming from, because you only have one huge client that you have to fight on behalf of. I know how that works. Brings back memories. All right, so we're going to go ahead and set it over for that same date, September
14.
2022. And I'll set it also at 9:45 a.m. I'll keep these matters somewhat connected because some of the same issues are coming up. And we'll address those issues at the next day. The court finds good cause for the adjournment of the pretrial, and the matter is set in court. Good day to you, gentlemen. Thank you again for your patience.
Thank you, Your Honor.
Thank you, Your Honor.